Hello, hello, hello. It's Attorney Mike Grevlin coming to you from Chicago. As usual, I took the day off yesterday, and I hate to admit it, I missed you. All right. Everybody sent me this clip. It originally appeared on, as a court stream. But I think everybody got it from Team Skeptic. Shout out to Team Skeptic. I'm poaching your clip. He's fast approaching 100. Go give him some love. He's a good friend of the channel. Also, I found a little nugget from Mark Baggett, also a friend of the channel. Also, give him some love. And while we're at it, I want to mention that that Big N crossed 20,000 yesterday. So give him congratulations are in order for him when you bump into him next. All right, let's get this party started. We've got soft sits. It's good times.
53 People versus Shannon Phillips, 17132 FH.
What I'm trying to assistant prosecutor on behalf of the people. I believe this is a collections type of show cause.
I think so. It's actually listed on the docket as a probation violation, but the judge file indicates it's collection show cause. So,
yes.
Your Honor, Mike Getty from the PD's office. If I might, I looked. It looks like there was a show cause. There's a show cause for failing to pay restitution, and also it looks like there's been collections matters in the past.
Yeah, there's a collections show cause set on August 10th, 2022. And this is, I think, just specific to the restitution because she was not complying with the payment arrangement for the restitution, and she's about to max out. It looks like it was hard to read. It looked like August 2nd. So her 5 years max?
Yeah, so Agent Smith indicates that she's reached her maximum probation, and she said that she will not sign a promissory note, which is the requirement once we can no longer supervise them once they reach their max term. And she's eligible for discharge, but she indicated to let you know that she said she will not sign a promissory note.
okay. Well, let's see if we can resolve this. Is Shannon Phillips or anyone representing her in court today? Ms. Phillips, are you there? Are you Shannon Phillips, who's identified as UCC 1-308, all rights reserved? Okay. Well, there's no response to the court's inquiry. It's 4:30 p.m. on July 13th.
We hear you now. Are you Ms. Phillips?
UCC 1-308, all rights reserved. I am here on a special visitation of the all caps name.
Who are you?
Okay. Seeing no response to my request, it's 4:30 p.m. The matter was scheduled for 1:30 p.m. Agent Miller, I will sign a bench warrant upon your submission. Failure to appear.
Your Honor, could I haven't been appointed on this matter. Could I encourage the UCC person to acknowledge whether she is the Sharon Phillip? Otherwise, there'll be a bench warrant issued for your arrest.
My name is capital S, lowercase h, lowercase a, lowercase n, lowercase n, lowercase o, lowercase n. Can y'all not hear me? My screen is lit up as if y'all can hear me.
Ms. Phillips, do you want a moment to speak with Mr. Gaddy before we proceed, or what would you like to do today?
Y'all can proceed.
I'm sorry, what?
Proceed.
Okay. Are you Shannon Phillips?
I am Shannon.
Okay. I'll sign the bench warrant when you issue it, Agent Miller. Feel free to send that up to my office and I will sign it.
To be dismissed with prejudice. How y'all gonna sign the bench warrant and I'm sitting right here? I told y'all what my name was.
Number 56 People versus Tyree Pitts, 21535 FH.
They mad.
Go to
I do not
consent.
consent.
Side.
Not applicable in any
I
way.
do not
reside with his grandmother in Florida for the balance of probation, and have no contact with his.
You're going to agitate me if you lie to me. I saw you. I'm going to tell you right now, I'm going to tell you one last time. You are going to agitate me if you lie to me. I saw you.
And don't forget to hit like and subscribe, or the dogs get it.
Looks like Ms. Walsh, are you going to be arguing this?
Clips.
That's correct. Good afternoon, Your Honor.
And I think I see a Jeffrey Lawrence.
Jeffrey-Lawrence, Cowgill, beneficiary.
Okay.
All right, that's all you need to know right there. Jeffrey-Lawrence, : stress on the colon.
So this is set for summary judgment today. I did have an opportunity to read the motion, the response, and the reply. So, Ms. Walsh, if you want to go ahead and make your argument, then I'll hear from Mr. Calgo.
Thank you, Your Honor. This case involves a defaulted vehicle loan for a recreational travel trailer. The credit union is seeking summary judgment on its claims for breach of the loan agreement, as well as for replevin to obtain its collateral. A plaintiff has submitted the declaration of Derek Howard, the small claims and foreclosure specialist for the credit union, in support of its motion, as well as the declaration of Michelle M. Bertolino from this office, and the Exhibit 1 there too. Despite all of the arguments that defendants have made in response to the credit union's motion for summary judgment, there are no genuine issues of material fact for trial. It is undisputed that
By the way, we're gonna go through this, but this is why I don't show you my hearing sign, on top of the fact that I can't. They're boring. This is a competent attorney having to point by point dismantle this nonsense, and it's long and it's boring, and that's what it's like when I go to court. She does a nice job, but that's the facts.
About August 14th of 2020, defendants executed and entered into a retail installment contract with the dealer, McCord's Vancouver Auto Center, for the purpose of purchasing a 2020 Venture 281 VBH KZ Stratus, which is a recreational trailer. And that is demonstrated by the Howard Declaration at paragraph 2 and Exhibit 1, which is a copy of the retail installment contract. Defendants also admitted in their answer that they did go to McCord's to acquire a travel trailer and entered into a contract. Pursuant to the contract, defendants granted a security interest in the trailer to the dealer, and that's at Howard Declaration paragraph 2, Exhibit 1, pages 1 and 4. There's clear language in the retail installment contract regarding the security interest.
It gets worse.
The contract was subsequently assigned to the credit union, and that's also shown at Howard Declaration paragraph 2 and Exhibit 1, page 3. There's clear language assigning the contract to the credit union. The credit union perfected its security interest in the vehicle, as notated on the Washington State Vehicle Certificate of Title for the trailer, a copy of which is attached as Exhibit 2 to the Howard Declaration. And that certificate of title shows defendants as the registered owner and the credit union as the legal owner of the trailer. Defendants defaulted under the contract by failing to make monthly payments as agreed, as stated in the Howard Declaration at paragraph 3. The last payment made on the loan account was on or about December 28th of 2021 in the amount of $359.24, as shown in the Howard Declaration at paragraph 3 and at Exhibit 3, which is a copy of defendant's December 2021 monthly statement showing that last payment that was made. Defendants admit in their answer that the last payment was made in December of 2021. The trailer has not been surrendered or repossessed at this time, as supported by the Howard Declaration at paragraph 3, and defendants have admitted this in their answer as well. The balance owing to plaintiff is the principal sum of $35,928.21, plus late fees in the amount of $53.88, plus
Agreed.
accrued interest in the amount of $1,325.37 through July 21st, 2022,
Fraud.
plus interest accruing on the principal at the contract rate of
Best
6.66% per annum
Let's tell you the best
from
evidence.
July 22nd, 2022 until paid. And that is set forth in the Howard Declaration at paragraph 4 and is also supported by Exhibit 4 thereto, which is a copy of the payoff statement for the loan, and also Exhibit 3, which shows the principal balance on the loan that has not changed since the last payment was made in December of 2021. Now, the amount owing may be reduced by the net proceeds from the sale of the trailer, after
Bama Mike in the house.
repossession and sale of the trailer. But pursuant to the terms of the contract, the credit union is entitled to recover its attorney's fees and collection costs, and that's at Exhibit 1, page 4, paragraph 3C. Now, once a motion for summary judgment has been made and supported by affidavits, the opposing party may not simply rest on the allegations in its pleading, but rather must set forth specific facts in affidavits or otherwise as provided in CR 56, showing that there is a genuine issue of material fact for trial. And defendants have not done so here. While they have submitted many pages of inadmissible hearsay, including excerpts from several books and alleged excerpts of statutes and constitutional provisions and postal tracking information and other materials, some documents that appear to have been drafted by defendants themselves that have names like condition.
That's an insult right there. Documents that appeared to have been drafted by themselves because they made no sense and the grammar sucked and it was in crayon.
Acceptance or a bill of exchange or a declaration of the Naturalization Act of July 1779 for Jeffrey L. Cowgill's status correction to the land and soil jurisdiction, not sea admiralty.
I get where you're coming from.
The defendants have not set forth specific facts in affidavits or otherwise as provided by the rule that would show that there is a genuine issue of material fact for trial. In their answer,
This is the thing. People think the practice of law is super exciting. She is doing exactly what she has to do to argue this motion. It's not exciting. The short version is these people refuse to pay for this stuff they bought. That's it. But when you raise a bunch of issues, you have to address them all.
Requested that the credit union fix their credit and that damages be assessed against the credit union for $50,000 based on allegations that the credit union allegedly rejected tendered payment under the UCC. And in their almost 250 pages that they submitted in their response to the motion for summary judgment, they elaborate on the allegations that the credit union rejected payment that defendants allegedly made by submitting a Form 1099A, like an IRS form, and a promissory note. But
yeah, it's not legal tender. It's that simple. They say UCC all the time, but they don't understand a damn thing. Yeah, this is not a form of payment that they need to accept. It's fraud. It's nonsense. It's not worth anything.
Those forms of alleged payment are not legal tender, and the credit union was not obligated to accept them as forms of payment. A 1099A form is not a form of U.S. funds. And defendants admit that they have not made payment on the loan since December of 2021. So in short, defendants have not contradicted and cannot contradict the facts that are set forth in the Derek Howard Declaration, with any admissible evidence. And as set forth in plaintiff's reply brief, none of the arguments raised by defendants in their response motion create a genuine issue of material fact. If the court would like, I can go through, kind of summarize those additional arguments that the defendants have made. first, the defendants have not created a genuine issue of material fact regarding their entry into the contract. Defendants have, kind of complained about the copy of the photocopy of the contract that was attached to the Howard Declaration. However, the Washington Rules of Evidence do allow the admissibility of a duplicate to the same extent as an original, unless a genuine question is raised as to the authenticity of the original, or in the circumstances it would be unfair to admit the duplicate in lieu of the original. That's in ER 1003. But defendants have not raised a genuine issue of material fact regarding the authenticity of the original contract. In fact, they admitted in their answer that they did go to the dealer and that they, to acquire a travel trailer, and that they entered into a contract there. They also made payments on the contract, the last one being in December of 2021. They admit that they're in possession of the trailer, which has not been repossessed. Defendants' other arguments in their written response also appear to acknowledge that they owe amounts under the contract, as they argue that they attempted to make payments thereunder. And as stated in the Howard Declaration, the contract attached to the Howard Declaration as Exhibit 1 is a true copy of the original contract that is kept in the regular course of business in plaintiff's loan files. And plaintiff has demonstrated that the contract and other business records that are attached to the Howard Declaration are admissible under the hearsay rules business records exception. Defendants argue that the Howard Declaration is hearsay because Mr. Howard was not sworn in. However, that argument is not persuasive because the Howard Declaration is signed under the penalty of perjury under the laws of the state of Washington. If you look at Howard Declaration at page 3, that is so. By contrast, the defendants have not submitted any affidavits or any other evidence under CR 56E that would create a genuine issue of material fact regarding their entry into the contract. Second, defendants have not created a genuine issue of material fact regarding their default. They contend that they didn't default under the contract because they tendered 3 separate negotiable instruments per the Negotiable Instruments Act of 1881 in compliance with the UCC. And they argue that, these are twice that they sent the credit union a 1099A form, and that the form was supposed to be used by the credit union to obtain payment on a defendant's loan from the IRS. However, a 1099A form is not a negotiable instrument. It's a IRS tax form that is required by the IRS to be filed after property used in a real estate loan has been foreclosed or abandoned.
My God, look at her have to justify the obvious. Just to give you perspective, if I filed this flaming turd of a response, I would be getting sanctions and possibly referral to the ARDC in Illinois to deal with this because it's absolute nonsense.
A 1099 form has nothing to do with defendant's vehicle loan with the credit union. And the IRS instructions expressly provide that the term property does not include tangible personal property, such as a car held only for personal use, which is the case with the travel trailer. Defendants also argue that they sent a bond coupon in the form of a promissory note to the credit union as an attempted tender of payment under the contract. However, defendants have not submitted any admissible evidence to support that proposition. And even if they had, that is not a valid form of payment. A promissory note is essentially a promise to pay a debt, which defendants did by entering into the retail installment contract, which then in turn requires that they make monthly payments using U.S. funds in conformance with the schedule required under the retail installment contract.
The judge's face is awesome.
Defendants also have not created a genuine issue of material fact regarding the plaintiff's damages or about plaintiff's right to immediate possession of the trailer. Plaintiff has established its damages by the Howard Declaration at paragraphs 3 through 5 and exhibits 3 and 4. as demonstrated by the defendant's monthly account statement for December 2021, showing the last payment that they made on the loan, and the payoff statement for defendant's account dated July 31st of 2022. Defendants do owe the balance that's set forth in the complaint and the Howard Declaration, and defendants have not submitted any evidence to contradict those undisputed facts. Defendants have not created a genuine issue of material fact regarding plaintiff's right to immediate possession of the trailer as a consequence of their default, and plaintiff's security interest in the trailer as notated on the vehicle title. Under RCW 62A.9A-609, after default, a secured party may take possession of the collateral pursuant to judicial process, which is what plaintiff is seeking here. And plaintiff is undisputedly entitled to judgment as a matter of law on its replevin claim. And finally, none of the other allegations by defendants create a genuine issue of material fact regarding their entry into the contract, their default thereunder, and their plaintiff's right to damages and to replevin. For example, defendants contend that plaintiff did not adequately validate their debt upon request. And the declaration of Michelle Bertolino from my office and the Exhibit 1 thereto demonstrates that this office did adequately validate their debt, and the enclosures to the debt validation letter sufficiently supported the debt that is owing by defendants. Defendants also contend that plaintiff violated the Graham-Leach-Bliley Act by allegedly sending copies of defendant's credit application in an unredacted form to plaintiff's attorneys. However, the Graham-Leach-Bliley Act does provide at 15 U.S. Code Section 6802 sub E sub 4 that a financial institution is permitted to disclose non-public personal information about individuals to its own attorneys to the extent necessary. And so even if plaintiff provided a copy of, an unredacted credit application, that would not violate the Act as a matter of law, given that this firm, the attorneys for the financial institution, is retained to pursue collection on this defaulted account. In short, defendants have not articulated a valid basis for any claim against plaintiff for violations of any statute, and more to the point, defendants have not raised any genuine issue of material fact that would preclude summary judgment in this case on the breach of contract and replevin claims that the plaintiff has brought. So the plaintiff asks that the court enter the revised proposed order granting summary judgment to plaintiff, and that the court enter the revised proposed judgment, with attorney's fees awarded to plaintiff in the amount set forth therein, supported by the fee petition that we also have provided to the court and to defendants. Plaintiff has left a blank in the proposed judgment for the court to award additional fees incurred for preparation for and attendance at the hearing today. And if the court has any questions about that, I'm happy to answer. But with that, I can stop there for now. Thank you, Your Honor.
She's right, but it was the long-winded version.
You're muted, Your Honor.
My apologies. Mr. Cowgill, I did, just so you're aware, I did read through your response, the attachments. So if you have, I'd like to hear what argument you have in response to counsel.
And I'm dumber for it. And of course, you were awarded 0 points.
Without prejudice, I, Jeffrey Lawrence Cowgill, with Teresa Ann Cowgill, the beneficiaries, make a special appearance sui juris propria persona under fraud, menace, and duress before fiduciary Basher. This is a Sesticate trust action, which you are now a real party in interest to. Yep. I'm the living, breathing man on the land and soil. The dead entity, all caps, Jeffrey Lawrence Cowgill, was expatriated, and I, the living man, have an unrebutted UCC-1 lien and security agreement with the all-caps entity, and Gary Basher serves as the entity trustee in a fiduciary capacity. Virginia law further provides to authorize such filing, the debtor must do so in an authenticated record by authenticating or becoming bound as a debtor by a security agreement, or 3, by acquiring collateral. I have supplied that to you. There's a UCC 1 claim. The plaintiff's agents are outlandish, stating Federal Reserve published documents are hearsay. Statutes and constitution.
Oh, the gall. He claims that her statements are outlandish.
Are admissible under 56B, as it states. The defendant may move with or without supporting affidavits for a summary judgment in such party's favor as to all or any part thereof. Since the plaintiffs have violated RCWs, UCCs, and U.S. codes, among other laws, these laws are fact and admissible per CR 56B. The plaintiffs.
That's his little subset version of all objections right there. He just said they've just violated law generally. He's just doesn't cite a provision actually.
Says the conditional acceptance is a nonsensical document, yet it is in Black's Law Dictionary under conditional acceptance.
Black's Law.
The definition is an engagement to pay the draft or accept the offer on the happening of a condition. A conditional acceptance is in effect a statement that the offeree is willing to enter into a bargain differing from some respects from the proposed or the original offer. The conditional acceptance is therefore in and of itself a counteroffer. We conditionally accepted the offer of the plaintiff, but the plaintiff ignored us, knowing that the conditional acceptance stated acquiescence would void the original contract. The postal tracking combined with the Esquire Scroggins letter is fact and evidence to the plaintiff receiving the bills of exchange that they did not return. The plaintiff's agent, Esquire Bertolino, admitted they received them as well. What qualifications does any of the plaintiff's agents have to declare what is and is not a bill of exchange? Since the plaintiff's agents, the Esquires, lied about the redacting and have submitted evident affidavits that they are not qualified to submit, how can their words be trusted? They are not bankers, nor is Mr. Howard. What is his qualifications to make such declarations? He looks at a piece of paper, the plaintiff's agents hand him, and he takes it as gold. I have people at work that know federal and state policies and procedures, but they're clueless as to what those policies and procedures are for. How can Mr. Howard be trusted acting as an entity's agent?
What?
No offense, lawyers lie all the time.
Oh no, that's cool.
Fact, Agent Howard produced a terrible photocopy that has a signature on it for the dealership that is not on our copy. Who signed the contract? Can the plaintiff's agents prove that an authorized representative for the dealership that is delegated by the plaintiff signed that contract? The plaintiff wants to rely solely on the contract, so let's talk about the contract. Who signed it for the dealership? Why hasn't the plaintiff gotten an affidavit from the dealership? Because they don't know who signed it. Washington rule does state that the photocopy can be used in the original's place unless there's genuine question of the original. And that alone poses a major question. Where is the original? Is a signature on the original more legible? Is there any other evidential factors on the original that can give us the answers to that truth? On the UCC, we did tender for payment bills of exchange, who the plaintiff's agents are not qualified to decide with their opinion what is and is not a bill of exchange. And as for where the bills of exchange are, ask the plaintiff. What did they do with them? They did not send them back. What did they do with them if not monetize them for gain? Esquire Bertolino states that the instructions on the 1099A state tangible.
I don't know what they did with them. Well, I don't think they have them anymore, but I'll tell you what they didn't do. They didn't monetize them for gain because they were worthless.
Property is not included, yet the exact wording is no reporting is required, meaning you don't have to, but you can. It does not say no tangible property, so Esquire Bertolino lied. The plaintiff has violated many UCCs, U.S. codes, not just 12 U.S.C. 5511B2, C codes and definitions on everything that the plaintiff has violated, and I have proven the facts. Why didn't the plaintiff return the documents they say are not bills of exchange with an explanation or dishonor? Why wait and have Esquire type up some bunk letter and still not return those bills of exchange? When you're doing something and you find out that there's fraud,
You know, when you're arguing a motion, you don't like ask a bunch of rhetorical questions. It's just the form of everything's wrong. Everything's wrong about it.
there's some shenanigans going on, you stop. That would explain why we made payments until we found out that there was fraud. Payments in fiat currency were being made until we discovered the truth and the plaintiff's agents violated laws and codes. All they had to do is return the bills of exchange with dishonor and or validate the debt or answer the conditional acceptance. Instead, they ignored us. That's why we're here. The Federal Reserve publications, like Hearing the Truth from the Horse's Mouth, state exactly how banks operate. How is that not fact? The Federal Reserve dictates what the banks can and cannot do. I'd say their publications are not only...
How is that not fact? It's a nice emotional flourish. Wrong as wrong can be and just silly.
admissible, but damning to the plaintiff's complaint. As the plaintiff, they have to prove their complaint, and not only are there holes in their contract theory because of the signature, but it begs the question, why are they dismissing the UCC, which all banks and courts are bound to? And why didn't they rebut the UCC one? And as for the Leach Act, I submitted the copy to the court from the plaintiffs behind a sealed financial record. There's no explanation for these agents or their office to be passing around sensitive information that the agents do not need. So they did violate the act. What is their confidential material protocol? Who has seen the documents and where is it stored? How was it sent to the plaintiff's agents? By mail, fax, email? So how can you tell me it was secured when they didn't take the precaution when they send it to me in regular mail, not certified? The plaintiff never asked if they could share our personal information of that magnitude. This alone sets forth facts to either dismiss or send this complaint to trial so the plaintiff's agents can be questioned. Put the qualified bankers on stand so we can find the truth. The plaintiff's esquires are not qualified to speak on the plaintiff's behalf. Mr. Howard is not a banker, so neither is he. I sent, and if you use it without prejudice, like I have, a 1099-A can be anything I want. I can write a bill of exchange on a blank piece of paper. It's what they do with it. They didn't send it back with dishonor. They didn't send it back at all. All they said is, well, now we're going to limit how you can and cannot pay. And so they violated the UCC. And with that, I'm done.
Are you done?
Any brief response?
Thank you, Your Honor. The retail installment contract expressly provides that the borrower the borrower agrees to pay the amount financed and the finance charge in U.S. funds according to the payment schedule below, as explained on Section 1 on the back. That's at Exhibit 1, page 2. It's undisputed that the defendants did not do so, that they defaulted under the terms of the contract. They don't dispute that they received the trailer. They don't dispute that they received this loan. They don't dispute that they made payments under this contract. They knew how to make payments under this contract, and they don't deny that they stopped making those monthly payments. There is no genuine issue of material fact that they entered into the contract, that they defaulted under the terms of the loan, and that they owe the amounts set forth in the Howard Declaration. It's, not appropriate for defendants to malign attorneys generally, or my colleague, Ms. Bertolino, in this court, with no evidence, no admissible evidence that would support any of the allegations that defendants have stated here today. There is no demonstration, no allegations, no demonstration of fraud by the credit union or by anyone. There is no defendants just simply have not created a genuine issue of material fact regarding the credit union's claim for breach of contract or its entitlement to replevin in this case. And that is, those are the plain facts.
So I got one question I have, which is not necessarily germane to my decision. Does your client still have the bills of exchange that were submitted?
That I don't have an answer for you today.
Your Honor, I've asked for them back and they just blatantly ignore me.
All right. Well, when I look through this, I mean, there's a lot of interesting theories that are kind of flowing all through this. What it boils down to, from what I gather, and there seems to be undisputed, is you folks went in, you bought a trailer on time, agreeing to make payments of some amount, pay it off. At some point in time,
Absolutely.
there was an issue arose where you decided to do something different, and then no more payments were made. There were some submissions of bills of exchange as an attempt to make a payment, as well as a 1099 as an attempt to make a payment.
This part right here kind of bothers me. He's trying to throw the guy a bone. He gets to the right place, but that's not an attempt to make a payment. And I would not elevate it to that level, even in being nice. It's despicable. It's dishonest. They know there's no money. It's nonsense. And to pretend that it has any merit or value or anything is encouraging bad behavior.
My answer to that is those probably would not be something you could walk into Safeway and buy a banana with, because it wouldn't be considered regular money for purposes of buying things in a retail situation. They may work in a UCC type thing or something like that. This is simply
absolutely categorically wrong. I don't know why he's offering that. That's disappointing. I generally like this judge, but that's disappointing. He's trying to be nice, and he knows damn well that everything this guy's doing is wrong and has no application in real life. None. It's not close. If he's confused about that, he shouldn't be on the bench. I don't think he is. I think he's trying to be nice and pretending that possibly there's merit. But he shouldn't do that. Like I said, he gets to the right place.
Consumer contract to buy a trailer and make payments on it. And when you're all done, you get the title. The credit union, it appears without any objection, has a security interest, which is indicated in the title as the legal owner. And I've not heard, I mean, there may be some other claims, but that you may have against them. I'm not making an assessment of that, because even if you did, it would not upset the contract to buy the trailer. So, I mean, you buy the trailer, you got to make the payments, you make the payments, they get the trailer back. So I am going to grant the motion for summary judgment. In doing so, I want to just give you some guidance, sir. What will ultimately happen is they get the trailer back, and then they sell the trailer to somebody else. And they apply the funds they get from that against the bill that's still owing. So the more money they get out of that trailer, the less money you end up having a judgment for. Does that make sense? So it's in your...
Oh, he's headed for a deficiency judgment. He doesn't care because he doesn't have anything, is my guess. He's definitely headed for a deficiency judgment. First of all, I don't know the market on trailers, but all these things depreciate much faster than you pay them off, especially when you're not paying them off. But the judge does give good advice there, which is, hey, you know what? Don't trash the thing, because to the extent that you diminish the value, it's only coming out of your pocket, theoretically.
Best interest not to do anything to the trailer. It's probably in your best interest to hook it up and drive it down to the credit union, because that would save some costs.
Oh yeah, I don't have a truck to do that, so they can come get it.
Oh, okay. I'm just trying to point out it's in
And
the,
so my copy of the contract not having a signature from the dealership doesn't matter.
it really doesn't.
And you being the trustee in this case doesn't matter.
Well, I'm not a trustee, sir. I'm a judge.
You are because I appointed you one
I
as the beneficiary because I'm not to do that.
I'd hold him in contempt right there. I mean, that's funny and all, but I would hold him in contempt. Don't you presume in my courtroom to say things like that. And perhaps why I'm not a judge, but I wouldn't. That you did not appoint me. I didn't accept any appointment. Don't interrupt me and don't spew this nonsense in my courtroom.
Okay, I'm not able to accept that as a Superior Court judge.
What about them just putting out our social security numbers without our say so? Like, they could have completely ruined our credit. Someone could have those numbers and be doing damage to us right now.
Well, if those were passed to the attorneys as part of the collection, then that would be something that would be allowed. If that was sent out beyond that, obviously that's a separate issue. And if in fact that were a claim that were proven, there may be something there. But again, that doesn't affect the contract. Those are all other claims that you may have. I'm not saying you do or you don't, because I don't know enough about those, even based on all the information that you filed. And I read through all the stuff you filed because it's what I do when I do my job. So,
So can we have those forms of payment back? Can you order them to return those to us?
Well, I think it's appropriate if there's some value in those should be returned to them.
There isn't any value, and you know it, Judge. And now you're going to add this burden to them. They have to return documents which they didn't seek, which have no value, and now you're placing that on the plaintiff. I absolutely disagree.
A lot of value in them if they still have them, and if they don't have them, then
what happens if they don't return them?
If there's any value, why did you finance this? Because you needed real money. If that had value, you could have just gone in and purchased the damn trailer with that.
Well, that'll be a different lawsuit. It's not part of this.
Okay, so what I'm asking is, can you order them to return those bills of exchange?
Your Honor, that is not there is no motion that is not before you today.
Well, see, I'm not a practicing attorney. I don't need to do all this attorney stuff.
Mr. Calgill, let one person talk at a time. First off, the court has a fair amount of discretion to authorize relief in a case like this. If part of my decision is that the credit union needs to return the bills of exchange, then they need to return the bills of exchange.
Which I would appreciate.
So,
please and thank you.
So I am
Oh, God.
looking.
I just want to smack him.
For some reason. Hold on a second.
Please and thank you. Pay your bills, deadbeat.
A lot of paperwork came through here this week.
Sorry.
Stuff. No, it's not you. I just had a lot of orders for today, and I don't looking sure. And for some reason, I am not finding those proposed orders. So, counsel, if I can have you submit I think there were proposed orders filed in the case.
Yes, and they were submitted with our reply brief in the same package as the reply brief. There's a proposed order granting the summary judgment, as well as a proposed judgment awarding attorney's fees. And Your Honor, we did ask that the court, we did leave a blank in the judgment so that the court could also include some attorney's fees for the preparation for an appearance at today's hearing.
Yeah,
If you want to resubmit those, I have proposed that were filed in the case, but I don't have anything that I can actually use.
Okay.
Have you submit new ones. If you want to include a certificate for attorney's fees specifically related to today's hearing, I can consider that as well. I mean, I don't have anything to base it on at this point.
Okay.
So for you folks, I am going to include within that order that the credit union will return the bills of exchange that they were provided.
Thank you.
Your Honor, I just want to interject that I'm not certain whether the credit union has those, but if they do, and to
Or
the
they be
extent that
returned. That'll be a different issue if they don't.
okay,
Awful.
thank you, Your Honor.
Thank you.
I'll await orders, and when I see them, I will sign them and enter them and return copies to everybody.
Your Honor, could I jump in for just a second? This is Lisa Waldvogel calling, inquiring about item number 2 that's on the docket. I have a 3:30 meeting with just a ton of agencies, DDA, it's a WISE team, with service providers, client of ours.
Counsel, I will finish this hearing. I'm scheduled to go till 4:30 today. I'll get to your case as soon as I can.
Okay, I was just hoping we could do it so I could attend my 3:30 meeting, but I understand.
I would appreciate letting me finish the hearing I'm doing before people interrupt me.
Oh, thanks,
Sir,
Your Honor. I thought you were done.
Are we done? I got to go get my daughter.
All right, so counsel, if you can provide those, I will send out signed orders to everybody and the addresses we have on the file.
Perfect. Thank you.
Okay.
Thank you, Your Honor.
Oh my gosh, it is a double rainbow. I cannot believe it. It's a freaking double rainbow.
Well, there you have it. Woo! Judge got a little spicy with that one too. Oh, well, she did interrupt the hearing. She did. But you know what? You'd be done, Judge, if you weren't indulging this sovereign citizen nonsense. He gets the right result in the motion. He grants the motion for the plaintiff, which is the right call. He understood everything that was going on. What he did is he tried to be nice and pretend like and throw the defendant a bone here just verbally, and then it causes a bunch of problems. Now he's ordering that they're to return documents that these people that have no value, that these people never wanted. And I wouldn't keep. I would throw that out if somebody sent it to me. It's garbage. It's absolute garbage. It's not payment. You know, so now we're wondering, do we have that sitting around in a file? Maybe they do, maybe they don't. If they do, it's not a big deal. But then, and then he's also absolutely encouraging more of this behavior. People will see this and say, see, even the judge acknowledged that this and his thing about, oh, well, maybe that works in some context. No, it doesn't. It doesn't work in any context. Don't suggest that it does. It's frustrating. That's frustrating. Okay, I'm better now. I'm better. Crazy stuff sits. Nice to see y'all. I'll see you soon.